Alrighty, it is 10 o'clock straight up, and so we're going to go ahead and get started. I know that some people are still signing on, but I think in the interest of time, we need to go ahead and proceed. I do want to compliment everybody who was able to sign on early, and I saw a couple jokes circulating as a way to pass the time, and that just proves once again that mediators are fast on their feet. And we are a very clever bunch. I want to introduce myself. My name is Chris McGee. I am going to allow my fellow panelists to introduce themselves as well when we get to our introduction slides. But I want to welcome you all to this seminar that we're having today, presented on behalf of the Grievance Fee Mediation section for the Florida Bar. And I'm advanced. Whoops, we went too fast, too many. All right, so here's what we're going to be doing here today. We're going to be discussing grievance fee mediations. The formal title of our program is Do's, Don'ts, and What Ifs. And you can see there the esteemed co-panelists that I'm sharing this hosting job with. They have come up with some brilliant thoughts and hypotheticals to allow us to explore some of the avenues and the contexts in which grievance fee mediations take place, and some of the circumstances that arise that might present ethical questions or put you in a quandary as a mediator doing the grievance fee mediation. Here is what this session is not. We are not going to spend the next 70 minutes talking about how do you mediate a case in general. We are going to assume that there's a basic level of knowledge that many of you have carried into this process, and we're just going to do our best to kind of highlight the areas where you can run into a little deep water and how you would get yourself out of that. I want to give you the preliminary information about this training as well. This is a 90-minute CLE, so it qualifies for 1.5. The CLE number through the Florida Bar is 7329. This course has been pre-approved by the Florida Bar for CLE credit. It has also been pre-approved by DRC, the Dispute Resolution Center, for CME credit as well. So if you're looking for an ethics credit in your CME, this will qualify for that. We had a question in our chat before we began about getting certificates. If you get audited as a mediator after you have supplied your continuing education information to DRC, they may ask to see your certificate of completion for the course. You're not required to send them in automatically any longer. If you need a certificate for CME purposes, you need to email Susan Austin at the ACAP office, and she will supply that to you. Of course, if you are a Florida Bar member, you just plug in the course number, and they have already provided the Florida Bar with all of the attendees so that they can corroborate your attendance here today. Susan's email address is saustin, AUSTIN, at floridabar.org. That's saustin at floridabar.org. And I'm going to ask Chanel to put that into the chat to everybody so that they can see that address in black and white, and you'll have it if you need it. I want to say one more housekeeping matter, and that is about the questions and the answers. We're going to endeavor to take your questions as we go through this, but sometimes we cannot get to them, and we also have a certain amount of material we need to cover as well within the prescribed time period. So we're going to be monitoring the Q&A box, not the chat box, the Q&A box as we proceed through this training. And if you have questions, we will do our best to answer them. If you have a question that doesn't get answered, you are welcome to email any of us, and we will do our best to get you an answer so that you're not left hanging with respect to that. All right, I think I have covered all of the housekeeping matters, and we can get down and into the substance. And we're going to go ahead and do that and start our introductions. This is me. I am a member of the Florida Bar and have been for quite some time. I run a mediation and arbitration practice on the East Coast of Central Florida in Brevard County. I'm a Florida Supreme Court certified circuit civil, county, and appellate mediator. I'm a Florida qualified arbitrator. I'm on the AAA panel for arbitrations, and I have been a proud member of the ADR section for quite some time. I'm a former chair of that section for the Florida Bar. And I'm currently involved with the Grievance Fee Committee at the Florida Bar, and hence we're doing this training. And I'm going to turn the mic over to our next presenter.
Okay, and good morning. I'm Linda Vitale, and I guess I'll say the number of years, although it's probably greater than Christina's. It might not be smart to say it, but I've been a Florida attorney for 53 years, and mostly in family before I went on the bench. I went on the bench in 1978, initially as a general magistrate and as judge, circuit judge in 1981. And that's a total of 32 years. And at the present time, I'm a certified Supreme Court certified mediator in circuit civil, county, appellate, and family. Also do some special magistrate hearings by appointment. And that's me, and I'll turn it over to Brenda.
Okay, my name is Brenda Thompson Gordon. I am a Florida Supreme Court certified circuit civil and county mediator. My background is in commercial property and casualty insurance. I have over 38 years in that profession. I am a Florida Bar mediator, Florida Bar arbitrator, and I'm a consultant expert witness and managing member with insurance and claims management. And I'm located on the west coast of Florida.
And last, Chanel, we're not trying to leave you out. So I'm going to ask you to go ahead and introduce yourself in conjunction with the next slide.
Great, wonderful. My name is Chanel Schuyler. I'm the director of ACAP and intake here at the Florida Bar. We intake all of the complaints against Florida attorneys here in our Tallahassee headquarters office. And our ACAP program, Attorney Consumer Assistance Program, is really a program that is meant to assist with trying to dispose of the unnecessary filing of complaints by maybe offering to give a call to an attorney or write a letter to an attorney to maybe mend that fence or invite the attorney to maybe communicate better with their client and so that there's not a complaint filed. A lot of times, though, we get complaints here that basically involve not only possible violations of the rules, like my attorney didn't call me, didn't get my permission to settle, didn't interview all of my witnesses, and didn't represent me as well as I thought they should have, and they charged me too much money. Well, we look at all of those things on the front end about the possible rule violations, and if we've resolved those to our satisfaction that there isn't anything that we're going to pursue as a rule violation, but then we have this other piece of the puzzle out there that is this outstanding dispute over the fees, then we refer the participants, the complainant and possibly then the respondent attorney to the mediation program. We also have a different arbitration program that's a Florida Bar binding arbitration program. But here we're talking today about mediation. And so that's probably the most common way that a file will be assigned to a program mediator. Our mediators are volunteers. They're throughout the entire state. This program is a free service that we offer to clients and attorneys to resolve their fee disputes. We don't charge them, so that we actually have to rely upon our wonderful program volunteers to provide a very valuable service. The other way a file could get to a mediation is by a court order from a discipline case, or possibly a diversion that is recommended by a grievance committee.
And if you are complete, Chanel, I will then go ahead and start with the fact scenario that we're addressing today. And
all right.
We
As for some,
well,
no, Linda, I was just going to say I'm not advancing. Oh, here we are. Now I did advance. I have my apologies. I hit the wrong button. So being technical wizard that I am, I have now figured out which button to press. All right. I apologize for the intrusion. Go ahead.
okay. So if you would like to advance to screen 8, I think. There we are. And screen 8 and 9 will go together, but we'll start with screen 8 and go through this briefly. When you now get the file from the bar, you should get the consents of the parties to mediate. as well as the names and a little bit of factual background that the parties provided in their statement. So it is now the mediator's obligation or duty to go ahead and get this scheduled as timely as possible, find an agreeable time, an agreeable location, or possibly Zoom. Now, I just want to make a little side note on Zoom because of the 2 rule changes in civil and family recently. Now you need the written consent of the parties in order to proceed by Zoom. So I've yet to find somebody that didn't want to proceed by Zoom, but in the event that they don't, then it would have to be a live mediation. Otherwise, Zoom will be fine, or whatever medium you use in order to get there. I don't want to be plugging just for Zoom, but it is kind of general practice that in legal profession, that's what we're using. So you've got the notice, you know when you need to notice it, and you'll also do the notice of mediation. After that, I suggest when you get close to the time, if it's your practice, as it is mine, remind the parties of the time and the date, the place for the mediation. In the Florida bar mediations that I have done, I have never had a participant that didn't show up. But I think it is also good just to let them know so you don't have to reschedule it. And then we're going to assume right now you're sitting there the morning of the mediation, and what do you know about the case? So if you go to what the Florida bar sent you, you're going to have Mary's position. And in this particular case, Mary's position is pretty much what Chanel was describing in her introduction. But it's an attorney's fee bill. The former client's Mary. She believes it's excessive, and her reason she believes it's excessive is when they went to the fee hearing, the court only made her husband pay, a former husband pay, a part of the fee, not all of the fee. So she's now assuming that that means she was overcharged. Mary also says that the attorney never returned her calls, and the attorney in this case is I am trying, ESQ. But he didn't return calls. The attorney also is billing for discovery that he never got. And she doesn't think that he should be able to bill for discovery that was not received. She also believes that Mark, her former husband, was ordered to pay a part of the fee, and that whatever part Mark is supposed to pay, she shouldn't be responsible for whether or not he does pay it. That's up to the attorney to collect. That's her position. Now, the attorney's position, of course, is there's a retainer agreement. Her hourly rate is stated. Mary is responsible for the fee, whether or not Mark pays it. She will be reimbursed when Mark does pay it. And he has provided copies of the retainer agreement and the bills so that you can see what time he has spent and exactly how he has spent the time. And by the way, Mary called constantly, and he means constantly. The background of this case, and you will have this as well, if you will just go to the clerk's webpage, pull up the file, and you'll see what the background of the case is. In this case, although there was a much more extensive background that we started with, and we've narrowed it down to the following. That Martin filed the petition for dissolution of marriage. It's a 16-year marriage. There's 3 children. There's a house, a small business. Mary didn't work during the marriage, or at least the last several years of the marriage. And Mary did not hire an attorney until after the default was entered. And I am trying, then pursued getting the default set aside. The case became very litigious. There were claims of domestic violence that Mary made and claims of false claims of domestic violence that Martin responded with. There's issues of equitable distribution, alimony, child support, and whatever issues you could find in a dissolution of marriage, they became important in this case. There were significant efforts by I Am Trying to get all of the discovery from Mark, but a lot of the discovery was not forthcoming, as Mary has mentioned. There's eventually a final judgment after a 2-day trial and a fees order after a 4-hour hearing. The attorney was able to secure copies of information for several accounts, financial accounts, which had never been disclosed to Mary prior to the litigation. Then after that, I'll discuss just very briefly opening statements. I'm not going to go through what you're required to say in opening statements, but there's an issue of whether, and I'm sure almost all of you know this, if you've got a pro se on one side, they're not focusing on what's really happening and what you're really saying and what the meaning of the words are that you're saying, particularly if you stick to the exact script as is in the rules. They need a little bit more information. So either before or after the mediator's normal opening remarks, you need to make mention of it. It's required in the rules that at the commencement of mediation, the mediator has to have opening statement remarks, which include certain things. You got to cover those certain things. But when you get to breakout rooms, that's the time to then get into what it is we mean by confidentiality and what it is we mean by voluntariness of an agreement and all of the other issues, self-determination, what we are talking about, so that they understand that they have a lot of input into this. It's not just sit and listen to what we have to say. They are the ones that are guiding the ship here, so to speak. We also, I'd like to mention of joint sessions. Joint sessions, I don't believe is something you really can decide in advance. Some mediators say that you always start in joint sessions. Well, that's fine if you have the feeling that the parties are amicable, but if they are hostile, then you are probably better off going at least initially to separate breakout rooms, because if they are hostile at the beginning of opening statements, they're going to be more hostile afterwards. So that's a food for thought, not to jump right in to the normal chain of thinking this. You got to start in a joint session to get a setting to see about cooperation and how far you can get in a joint session. A joint session may sabotage your mediation if there's a real hostile relationship at this point between the attorney and the client. I'll leave it go at that for now, and we will start with the next, which the first caucus. After you've done the openings, potentially.
Okay.
Go ahead.
All right, so the first caucus, after discussing the case for a while, and we go into a breakout room, Mary says, I don't know what to do. And then she asks, what would you do? What should I do? How much time should an attorney take to do each of these things on the bill? And these are all very common questions, all legitimate questions and questions that beg to be answered. However, they're questions that could cause a mediator to violate some of the Florida rules of professional conduct if in fact they don't answer them properly. Now, knowing that there are people in the room in this training session today that may not be governed by the Florida mediators professional conduct, just know there are some common threads in the process that we're going to be sharing with you today that you can modify to fit your circumstances. But you will want to apply these standards to ensure integrity to the situation. Keeping in mind that the mediation is designed to encourage and facilitate without prescribing. So we don't dictate to the parties what they're doing. We're there to assist in identifying what the issues are and helping them to come up with their own solution. Now, the first question is, I don't know what to do. And that's a very common question. My approach is to, and I use this term common quite often and multiple times in the mediation, and that is, these are your options. So it takes away the idea that they don't know what to do, because you're telling them these are some of your options. And that, in my opinion, gives the party the feeling or the comfort that they're not being dictated to, but instead they have options. And then that opens up the discussion for what ifs or presenting what really is important to them in resolving the case. The next question is, what would you do? And that's not a question that you can just openly give your advice, because if so, that would be a conflict, and also you would not be remaining impartial. So I often will say to them, I can't tell you what to do. This is a process that is designed for you to discuss what it is you'd like to see happen here today. Also, how much time should an attorney take to do each of these things on the bill? That's a very common question too. And even though that may be something that all of us have experience in, we are not there to now reduce the mediation to a process of giving them advice, reviewing the attorney's bills, and telling them what doesn't make sense or passing judgment on that. So, you know, there's a line there between being a mediator and being an advocate, and you can't cross that line and then provide advice. So when it comes to, you know, how much time should it take, then I turn it back over to the person, the pro se individual, and say, are you familiar with these charges? Have you made contacts with the attorney? And oftentimes they can say, yeah, I call them a lot, but I didn't know they were charging me every time they picked up the phone. And then so that provides you with an opportunity to have a discussion that says, yeah, some of these, you know, charges that appear here are things that you recognize. So from that standpoint, I want to make sure that with regards to this whole concept, that we do keep in mind that it's up to the parties to decide and determine what the outcome will be, not the mediator. Mediator's responsibility is for self-determination, impartiality, and definitely avoiding conflicts. So I don't know if, you know, how some of you all may look at individuals that come to a mediation, as in most cases, a pro se individual who oftentimes are more so not familiar with the process. And so having that first discussion, as Linda indicated, is going to be an opportunity to explain to them what the process is and some of the things that could happen. So kind of giving them an education on what can happen from this point forward in the mediation process. So that's kind of my take on how I would address what should I do type questions, listening, but all the while bringing it back to the individual and helping them to isolate what the specific issues are. And I think we have on the screen what the some of the issues that were presented, and that is with regards to the particular rules. I think, thank you, Christina, for putting that up, but the parties here can probably, I mean, the people observing can probably review those. Or if you have any specific questions, you can just ask me.
Thanks, Brenda. I'm going to go ahead and talk about the next caucus, but the reason I put these rules up here, as you noted, is these are the ethical rules that apply to mediators who are certified in the state of Florida. And we really do want to just highlight some of the things that are in those rules that will help guide you through this process. Those rules are there. Obviously, they've been well thought out and have had a lot of effort taken with them to give mediators some concrete input into how do you handle these kinds of situations. And once again, I'm not moving ahead. There it is. Okay, so the next caucus is this. You complete that opening session, as Linda indicated. You go into an initial conference with with Mary, who is the person who has filed the grievance against attorney trying. And then you go back to attorney trying and you have an opening session with attorney trying. Now, we're not going to cover that opening session with attorney trying. We are going to move forward with some of because attorney trying does present some ethical issues to us as we proceed through this, but not right away. So a discussion is completed with attorney trying, and the mediator comes back to Mary's caucus room, and she's had an opportunity to look at the bills, and she says, can you explain these to me? I don't know how much was charged. I don't know who was charging, who performs the service. How do you interpret all of this? And what do you think about these bills? Now, Brenda has touched on the issue of what you might say in those circumstances. I'm going to take a little deeper dive in it. The first place that I'm going to start with is we have these very 4 pertinent questions. Can you discuss the scope of work that you see in the bills? I think the answer to that question is yes. If you have the experience, because you may be an attorney, you may have billed clients in the past, you may be familiar with the litigation process and how discovery works, then if the person who is sitting in front of you as a pro se, as we have here in our hypothetical, doesn't understand what is outlined in the bills in terms of what is the scope of work, I do not see any conflict at all in having someone who has the experience and the ability to describe that to a pro se grievant about what happened and why it may have happened. No problem at all. Offer an opinion on the amounts billed. Gee, Chris, would you have billed me X amount for this discovery? Don't walk into that briar patch. That is not your role as the mediator in this situation. And, if you are asked that question, you just need to deflect it to say, things get billed for different reasons in litigations. We all know that's true if we have practiced in this arena. In fact, you may be a lawyer who is mediating this, or a mediator who is not a lawyer who is mediating this particular grievance, who has 0 experience in the family law court. And so that is another way to deflect this. I'm not here to talk about or offer my opinion on the amounts billed. Remember, Mary, that I am here as a neutral facilitator. I need to stay impartial. One of the slides that we just did has the ethical rule that reflects the mediator's obligation to the mediation process. It's your role to keep it fair and balanced, to make sure that the playing field doesn't tilt one way or the other. And the difficulty when you have a pro se sitting in front of you who is unrepresented, which is why they're pro se, is that it is so tempting to fall into that role of helping the person. And you sort of find yourself getting gently nudged out of the role of the neutral facilitator. And sometimes not so gently. Sometimes you are yanked by the throat into the role of, what do I do? You need to help me. I don't understand any of this. What are we going to do here? Right. So we've already covered some of that, but you got to be on guard against it. And you have to keep gently reminding and do that very gentle pushback to the grievant about there's certain things you can do in this role and certain things that you can't. And once you make that clear and draw those boundary lines, you're in great shape. Can you discuss the necessity of the items billed? I think, again, that depends on your experience. If you happen to be, like Linda, somebody with decades of experience in family law, I think that you will have a far more robust discussion with that pro se grievant about why the lawyer put these items down, what the lawyer was trying to achieve, how the lawyer actually achieved certain goals for the client. You remember Linda referred to in the remarks about the hypothetical that in fact, attorney trying was able to establish the existence of certain financial accounts that Mary had no knowledge of, and that were certainly pertinent and relevant to the court's assessment of the marital assets in the dissolution process. Right. So Linda can do that. She knows about all this stuff and she's going to go in there. I wouldn't necessarily do that. I wouldn't necessarily recognize discovery put on the page in a billing caption as relevant to that particular fact. But that's why Rule 10.370 exists. If you have the relevant experience, you are permitted to offer advice on those things. You are not permitted to offer legal advice, however, right? We're not permitted to guide either side in terms of this is what will happen if you do this. We are entitled to raise questions about the benefits and the risks of taking certain positions, but it is not our job to tell somebody what the outcome will be based on what our particular prior experience has been. And with that, I'm going to turn it back over to this one is yours, Brenda.
Is that Mary wants free counsel?
No,
No.
you skipped me.
Oh, I'm sorry. I didn't mean to skip you.
Screen
I
16.
apologize.
Screen
I
16.
did not. I read too quick. Go ahead.
Okay, now we go briefly to see I am trying, discuss where he is on his bill, and I'm back again with Mary. And at the very outset of the discussion with Mary, she brings up Martin, the ex-husband. And before I go into my session on this one, I want to make note that during the final 5-6 years I was on the bench, I had an all pro se division. I had no attorneys and just pro ses. So I sort of, that when we did this fact pattern, like that, this is like the fact pattern I know is going to occur at mediation. And it has occurred at mediation as well, but it's like, you know what they're going to ask, and you know from being on the bench that this is probably what the mediator is going to face, that the court doesn't have to face. But it's a more difficult situation that you get as a mediator, trying to move forward with their case and also not cross those lines. But with that said, we have now told Mary 3 or 4 times we cannot be her lawyer, we can't give her advice, and now she's grasping at straws because she doesn't want to go out and expend more money for an attorney and then end up having to pay I am trying also. So now she's looking for Martin's advice. Of all people, of course, now you have a slight gasp of breath and several thoughts that dart through your mind. The first thing is, this may not be a good idea because Mary and Mark just went through a contentious divorce, if you recall that from the fact pattern. So their relationship cannot be that of good friends, or if it is, it's certainly changed rapidly. So that's your first thought, that this may not be where you want to go with this mediation if you expect to try to get it resolved. Next thought that runs through your brain real quickly is, didn't I remember something about a domestic violence case in this, or allegations of domestic violence, and then allegations that Mary was making it up, and just what is going on there? That's the backdrop for several of the rules that apply here. And first of all, this confidentiality. So now once Mark is part of the scenario, he now, if we let him in, is going to be bound by the same rules of confidentiality. And the mediator would need to address that with him, the same as you would in an opening remark session with the client and with the attorney. The biggest question here is self-determination. What sort of influence is Mark going to have on Mary? And what exactly was the domestic violence, and what relationship they have during the marriage? Maybe just his sheer presence is going to prevent her from having self-determination. And why is it she's asking him for advice? You know, there's a lot of intricacies of domestic violence. If you listen to experts testify about the reactions of the two parties that are involved in it. And if we're not psychologists, we may not pick up on all of it, but partly it could have a significant impact of whether the decision that Mary's saying she's making is really her decision or that of Martin. And why is Martin willing to assist here too? You've got to consider, what is the motivation Martin has? You know, it's not out of the goodness of his heart, unless he's trying to get Mary to pay all of it, but we will find out shortly that that's not the case. You need to be sure that you're not taking sides. You're not trying to force Mary into a position of not having assistance. And it is their mediation. If that's what she really wants, then you may have hesitancies on what can be accomplished with Martin, and may not want to see Martin as part of this mediation. But if she's insisting on speaking to Martin, you've got to speak to I am trying about it and get his input and see what is going on before you address it with Martin. And he may also have a different perspective on the domestic violence issue.
Linda, can I just interrupt you for a second?
Mm-hmm.
If you have that conversation with the former spouse, with Martin, and you're going to inoculate him for the confidentiality issue to make sure that he understands if he does participate, he's bound by the confidentiality rules, etc. How far do you go with Martin in terms of sussing out is he going to be coercive? Do you just kind of brush that lightly in this little first opener?
No, not real lightly. That's why I think before you even decide what you're going to do about Martin, you're going to be speaking to I Am Trying, because I Am Trying may also have some knowledge of this background of alleged domestic violence and alleged falsehood of domestic violence that you're not aware of and won't get from Mary. So before I would make any decision on it, it's not my decision, by the way. That's what I was trying to point out. Oops. Before you would finalize whether Martin's going to come in and under what conditions and when, you're going to discuss it with I Am Trying. He certainly has a right to know who's present at the other mediation room. So you can't do that until you've spoken to him. If that answers your question, you're not going to brush it by. I'm not going to say to Mary, you're okay with this. You know, you're not afraid of him. Nothing's going to happen, right? And she's going to say, right. But no, it may not be right. She may not be able to think clearly with him there, or she may be overwhelmed with what he's asking and have reasons why she's reluctant to resist what he's saying. You don't know all those things about whether the extent of the domestic violence or whether it was just that one in our expanded fact pattern. It was just that one event where Martin shoved her and she called 911. I mean, that was what you knew from the expanded fact pattern that we had worked on, and we narrowed down because it could have taken an hour to just do the fact pattern. But when you do review the court file, you will have more information on the domestic violence. But in our particular fact pattern, there was never a domestic violence case filed. It was just allegations made in the pleadings, the petition, counter petition, that you saw it brought up. So you will have some information from the court file because there will be some description of events that occurred in the court file. So you can assess that and deal with that as well. Any other question? Where was I?
No, I'm gonna look. I think we're gonna move on to the next scenario.
Oh, I was not quite. I'm
backing up.
After we talk, let me back up for a minute. After we talk about the domestic violence, I was going to say we are first going to talk to I Am Trying and find out what his view is, but his view doesn't really carry the day. You're going to find out information from him, but Mary is really going to carry the day on whether she wants Martin to assist. But potentially in the back of any attorney's mind is probably, this is not a good idea. So, you know, if you can find another way for Mary to get assistance, that might be the better option.
And Linda, do we want to talk about the sort of the practical response here too? Is even if I Am Trying said no, I am not comfortable proceeding if Martin now participates. Or even if and for some reason you end up saying, well, you know what, I Am Trying is not going to proceed if Martin participates in your caucus room with you. There is always that issue that every mediator faces. Isn't that true? That you cannot control what the parties do when you leave the breakout room. True?
Yeah, I was going to get into that later, but because later it gets worse. But yeah, and even so, with any case, they're texting each other in the middle of mediation. On the family cases particularly, which is the worst ones to be doing it on, but they're texting each other during the time you're in the other room. Or if you're taking a break, then they're definitely texting each other, it seems. Some of the texts are now nasty, so it's just aggravating the situation. So you can't keep them from doing it. You'll tell them not to, or you can ask them not to. I don't even know if you can tell them not to. It's their mediation. If they want to discuss it with each other, I guess they can discuss it with each other. If we discuss it with each other and they have a tendency to continue to do that, you might consider going back into a joint session so that you cut out some of the hostility that's about to come forward in just texting each other.
All right. Have we exhausted this one? Shall we move on to that?
We have.
can do her next? Okay. All right. This is to Brenda. And why is this not advancing? I'll tell you what. One more thing. That's it. Oops.
There we
No.
go.
There we go.
So we caucus now after discussing I am trying's concern related to unbilled hours and the extent of the client's contact with his office. Mediator returns to Mary and Mary asks or says, I don't know the law. I'm not an attorney. If you can't help me, should I be entitled to a free attorney here to help me? And first of all, the fact that I don't know the law and I'm not an attorney raises the issue, is Mary capable of participating any further? I don't want to pick on Mary or beat up Mary, but it appears as though in this scenario, she's all over the place. She's asking for someone to make decisions for her. She's not presenting in a fashion that would make me believe that she is able or willing to participate any further. So you have to think of that in the back of your mind. What is Mary saying by, coming up with all these excuses? I don't know what to do. I'm not an attorney. And the next question is, should I be entitled to a free attorney? The answer definitively is no. The party is responsible for selecting and compensating whoever they choose. And also, free counsel is not part of the Florida Bar's program. So you can appear with or without counsel. That's the instruction that's given, and that's at the choice, that's at your cost. So that's to answer that particular issue in a nutshell. So it would appear, though, with all the questions that have come forth and all the different changes, bringing the husband in and having him, participate in the process, or take some responsibility, points to the fact that perhaps Mary is not in a position to move forward. And if we're not able to move forward to get the issues put down in writing, then it's up to the mediator to decide, is this case, should we adjourn it? Should we try some other options? But knowing that the mediator has the authority to do so, the mediator has the authority based upon the things that have happened during the mediation and their interpretation of what's happening to decide. And the rule 1040-420 allows for adjournment if the party is unable or unwilling to participate. Coercion is not an option, although it may seem tempting to some, but it's not an option. And so it's a matter of determining, or the decision that the mediator must make. Is this person willing or capable to proceed on? And that's a real question that comes up at different times. And although we want to move cases to closure or move them along, sometimes we just have to make that decision to impasse.
Okay, before we proceed, I just wanted to review a couple of the questions that have appeared in our Q&A. And I think we did say this, Linda, but several questions are raising the issue of whether attorney trying would have to consent to the participation of Martin. And I think that you did say it, but we had a couple questions about, can we do that? If I am trying says no, can Martin be permitted to join? And I think the clear answer to that is no. Martin would have to be foreclosed from the process, which raises the practical trapdoor of how do you control the communication between Mary and Martin if you're in the breakout room with attorney trying. Okay, and
Can I comment on that?
Yeah, please do. Go,
Okay,
Brenda.
so with regards to the attorney saying, I don't want him to participate any further, I would look at is Martin, we're here to discuss this fee. If Martin is the one with the purse strings and he's going to give you the money you want, do you not want to allow him to participate in this? Because we may be getting you the end result of what you want. And sometimes the parties can't separate the issues from the person, but it's up to us to help them, bring them back to the issue we're here for is fee-based only. And it's not a matter of if you like the person or any other things that may have happened. And so I give them that, I present that to the other party and ask them if that's something they want to consider to allow it to move forward. And so that could be an opportunity to move it forward. But I also think what's real important is that if Martin comes in, if he's going to participate right away, he needs to hear my opening statement, confidentiality, and be willing to abide by all those things. So that's the point that I would bring up.
And I'd like to follow up that just very briefly, and it's not even to that extent, but even to the extent that you just need to tell I am trying, look, you're here to try to settle it. If we're not going to be able to settle it because Mary needs some assistance from somebody, what does it hurt you just to move forward a little bit? And if you don't want them in the joint break, in the joint session, and this is jumping a further ahead too, if you don't want them in the joint session, so be it. But maybe we can compromise with Martin being there when I'm in with their breakout session. So I think that there's a number of ways to deal with Martin. And I'm not sure we've ever really let Martin in the room yet, but he's there somewhere.
He might be there in some circumstances, and in other circumstances, he may not be there.
Right.
But I do think Brenda raises an excellent point, which is sometimes you get the best friend, you get the, the support system, the mom, the sister, whoever it is that somebody needs in order to get through the process. And, it may not be fully acceptable to the opposing party here. I am trying. Nonetheless, the practical effect of having that person either in the joint sessions or only in the caucus with the other party is enough support, enough moral support, if you will, that they are able to move forward and reach a decision. Because as Brenda also points out, what we have gotten a lot of from Mary so far is, I don't know, I'm not prepared, I'm not capable of doing this without some kind of assistance. Is that really Mary? We don't know yet, because we're still going to develop this hypothetical, but we're going to move on to the next one in the interest of time.
And the next one.
Hang on, let me get it to go, because sometimes it does. There we go. It's there.
All right. So now we are back over with I am trying. You walk in the room and the attorney starts again. All she ever did was call. I didn't bill her for half the call. She called. And you've heard that 2-3 times now. He wanted to explain the extent of the calls, and you were almost ready to blurt something out, such as, really? Please, at least, could you stay focused? So rather than that, remember, you've not had a break. They've all had a break. Every time you're in the other side's room, they can, well, hopefully they don't chat, but they have been. They have a chance to get a soda, to have a cup of coffee, sit back, relax, get their thoughts together again. But you've been darting back and forth to room and getting beaten on from both sides. So you haven't had a break, and you're almost ready to blurt something out you shouldn't. So now you're about to be discourteous. And that's one of the rules. If you look at the things you need to be, it's courteous. And that's not going to be very courteous if it comes out of your mouth. Well, there we go. Your demeanor is also frazzled. And you're really about to lose control of the session by losing your own control. And your real issue is how to get back control without controlling the outcome. So if you take a break, you can do that. What am I missing? Where am I not getting where I need to go on this case? And part of it is you need to let Mary get some information that she probably doesn't understand, and now has been told you can't give her any advice about and doesn't know what to do with. So I think we're at the point where we need to have a joint session, if not to really discuss what they're willing to do with each other as an ultimate outcome, if that's a delicate situation, but what are the bills about? What doesn't she understand? I am trying is really the only one here that's going to be able to explain some of the questions she has. So we need to get back in together and discuss those items. And maybe those are some of the things that she might have been wanting to ask from Mark that she figured he knew more about than her, because he'd probably be getting more bills than she was. So that's something that you would probably get yourself to do if you just took a break. And I know this is like, do as I say, not as I do, because there's times I'm going, and 4 hours went by and I haven't had a cup of coffee. I don't function well without that coffee. So it's like, you need to take that break. Just, so somebody's looking for you for those 5 or 10 minutes. You're just not around. On Zoom, they don't even know where you are. You're in breakout room number 6. You just made up extra breakout rooms for yourself so you can go somewhere when you want to be somewhere other than with the 2 parties. Take the time. You need to focus on how to get back on track. You need to be courteous, watch your demeanor, be patient. Because if you try to rush everyone, that's going to unravel. But at this point, you're going to have a discussion about going back to the breakout room with the attorney. You're going to go back and discuss with Mary that this might be the best way to approach it because she does have questions, and only I Am Trying is going to be the one that really can answer those questions. And before you go back to Mary, you're going to have that conversation with I Am Trying about Martin. Even though he may not be the determining fact, he has a right to know what's going on. And you do find out somewhere along the line here that he doesn't have the resistance to Martin that you might have expected that he would. So you're going to try to regain control, and it gives, even the joint session gives you a little bit of breakout room, your time. You're not the only one talking. The attorney now is discussing the bill. You can sit back and see a little bit how that's progressing and whether Mary had a point or she just doesn't understand the bill. You're going to get a little information yourself. And make sure that breakout session, I think, has a specific purpose so that the parties don't get into a tangle with each other if you think that that's the relationship they have at this point. Kind of direct the questions. Mary's going to ask the question. She's going to give you the area she's concerned about, but if she's not making the point, I think you can maybe address it with the attorney and like what section she would like you to have explained. That is about where I am on this. So we're going to have a joint session. And we're going to get questions answered. And then I'm up next anyway. So we're going to the next group of slides. But we've done that now. We have had a discussion in the breakout room, in the joint session, but now in the breakout room, we have an additional discussion with Mary. Mary now really does want to settle this. So hopefully the discussion we had in the joint session really has been what she needed, and she's got answers. She's read the bills. She understands the bills. She wants this to be over. She doesn't like the uncertainty in what her future is. She's only got so much money coming in from Martin. She's got certain obligations. She just needs to move on. She makes an offer. She's going to pay. She wants to offer I Am Trying 50% towards the balance of the fees that are not to be paid by Martin, or 75% if Martin does not pay the part he's been ordered to, but only if reasonable efforts are made to get it out of Martin. And then she would be willing to resolve it. And my comment is here is Mary really does know what she was doing. Or at least it appears that way, or has she been texting Martin again? But it's unlikely that she's been texting Martin again, because this offer does not really go to Martin's benefit. So there could be worse things coming down the pike here that you would know that there's a problem with Martin, but this one does not really seem to raise a problem with Martin, and looks like the mediation is moving forward. You're checking on you're checking off the boxes of you think that she's exercising self-determination. You're not really quite ready to throw in the towel and call it a no agreement case yet. And the next issue does sort of present. The next slide is part of this issue, so we can go to slide 24, I think.
But before we do that, Linda and Brenda, I want you to opine on this too, because a question has come up in our Q&A that says essentially, and I'm going to interpret this because I know that it's truncated. And if I misinterpret it, whoever has submitted the question, feel free to submit it again. But it says the mediator cannot give advice. But if you're an attorney and you're willing to do that as the mediator, is that okay? Brenda, you want to take that?
I think the answer is no. The advice you're giving, if it's legal advice, you can't be giving her legal advice. You can't tell her what it is she should do. You can make recommendations, or you can phrase it something that she can answer. What do you think about? If, you know, that's the normal way to not give advice while giving advice is, do you think this is a possibility? Do you think this is an option? Have you considered this? But you can't give her advice and tell her what to do. That's my
Right. So Linda, for example, even if you were a lawyer and you were handling this mediation, you would not be providing the framework for how this matter might be resolved the way it's presented on this slide. You might try to, you know, Mary seems to have put this together either in consultation with someone else or on her own, but this did not come from you as the mediator. This is these, you know, among your options are, you could do this and these kinds of specifics.
This is directly from Mary when you go back after the joint session. This is not what the mediator came up with. This is from Mary.
Okay.
Somewhere along the line, if Mary's saying she doesn't have the ability to pay, well, are you willing to make some sort of offer on these fees? What is the amount you're willing to pay? Or do you need a payment plan or something like that? You could make those suggestions, I believe, but you can't tell her specifically, here's an amount I think you might want to consider. Let her come up with the amount initially. I am trying is going to come up with a different amount. You run back and forth until you find where they're really at, or the range they're really at.
And Brenda, would you want to comment on that question?
Yeah, I would agree with you, ladies, that you cannot give advice. And as a matter of fact, there's a MEAC opinion that's kind of similar in that even if as a mediator, you present some case law that supports one person's opinion, but doesn't support the other person's opinion, that is considered a conflict. So I would stay away from advice or saying this is, you know, I try to choose my words very specifically, and specifically it comes back to these are your options. And so I never say it in a way that this is advice, because I don't want it to be construed as a conflict.
And I think this might even, the person that needs the most help, you can give the least help to. That's the real problem with all of this, because she really doesn't know. She's not a lawyer. And if you have a case and the attorney if she's represented by an attorney and the attorney isn't correct on the law, you might want to say, well, have you considered the issue that such and such? Because if the attorney's wrong and you have a case and you know that that's the case, you need to redirect the lawyer. But you can't really redirect the pro se that she's wrong in what she's asking, because then you'd be giving her advice. So I go back to the person that needs the most advice, you can't give any to. It is really the problem. Or it's not that you can't give any, but you can't do it as directly.
Right. You have to walk that line between neutrality and advocacy. And it can be very tricky, which is why we chose the pro se scenario for this training exercise, because it presents all of these issues and tenfold. And you can think of another 100 ways where the neutral facilitator might be tipped off the bar and into the deep water. There is a second question on a different point, going back to confidentiality. It says texting Martin, but that's a violation of the confidentiality of the mediation. I think we would all agree, you're absolutely right. That violates the confidentiality, especially the way we're going to describe it to parties in the opening session or to a party that comes to the mediation, if that is permitted during the course of the mediation. Nevertheless, we were trying to point out that there is this practical issue that comes up in many, many mediations where, for example, Brenda referred to MEAC, which is the Mediators Ethics Advisory Council that provides opinions about how to interpret some of these ethical rules. And there was a question a while back when cell phones were becoming omnipresent in everybody's life. Everybody had a computer in their hand. And can you tell the parties to turn off their cell phone so that they will not be communicating with others during the mediation, which we cannot control, so it could violate confidentiality, and or where the parties would be getting information from who knows what source and not paying attention to what you have to say as the mediator and not really attending the session, physically present, mentally absent. And that MEAC opinion says, as a mediator, you are not permitted to tell the parties to turn off their cell phones or to put them in a box or any of those things that, you might be tempted to do because that's not your role, right? Self-determination is self-determination, and you've got to work with what you've got. So having said that, I think we have cleared out some of the questions, and
we're back to screen 24.
Yes. And that is where I'm trying to go next. And there we go. All right.
So screen 24, Martin's involvement is not exactly as beneficial as you might have hoped for, because now there's another offer on the table. And the offer on the table is that he's willing to pay for I Am Trying's entire bill, what he was supposed to pay, what was left for Mary to pay. And they want to enter into an agreement that I Am Trying gets paid. But there's a side agreement. And the side agreement is that Mary's going to have only 25% of the timeshare and Martin's going to have 75% of the timeshare. And then the issue arises, not only is she coerced, which now seems to be a rather reasonable assumption for going from probably having more than 50% to having only 25%. Self-determination, is there any self-determination she's exercising? But even so, more than that, we raise the issue of legal impossibility. They want this as part of their agreement. They both are saying they want it, but now you're left with the position of it may be impossible for Mary to fulfill, or may be impossible to enter this agreement and have it adopted by the court, because the agreement that they are suggesting as a side agreement has to go in front of the court to be adopted. You have to presume the court just got done with a 2-day trial, some of which was a contested area of time sharing. The court made a decision on time sharing on what they felt was in the best interest of the child. And now something else is coming along in the middle of mediation when they were talking about money for the attorney. And the court may not adopt the agreement that is the underlying motivation for Martin agreeing to pay for the entire bill. So he's paying the entire bill. She's going to give him more timeshare than he has, but she may not be able to do that under the court order. Now, between the two of them, just like on cell phones, you can't keep them from talking on cell phones. They could voluntarily exercise a different timeshare than what's in the court order. But as far as what can be ordered by the court, she may not be able to obtain an order doing what Martin wants here. And now you really have a problem. The biggest problem is self-determination and how you address that.
So Linda, can I just ask you this question? If you were presented with this in the mediation and you know that the court's got to approve it, do you suggest to all the parties that this may be a way to get the case settled, but there needs to be a recognition that that some of it has to be subject to court approval, and that I Am Trying,
I was about to suggest
that?
I was about to suggest that Martin, by agreeing to pay it all, has almost is making himself a party to this agreement. And then Martin, not only does Mary have a right to seek, and this is jumping ahead to your issue, but not only does Mary have a right to discuss it and have an attorney review it with her before she signs it, but Martin should as well. So my way of getting out of this one would be a couple of ways, but basically to tell them that, well, you're asking me to do an agreement that's not just a 1 or 2 liner. It's an entirely new timeshare plan. And I want to get it to you. I'm not saying whether I agree with it or don't agree with it, but if this is your decision, I will type it up for you. I'm going to do that this evening. I'll get it to you in an email. And when I send that email, I'm going to send what they're agreeing to, but I'm going to send an email that clearly says that you have a right to seek counsel before you sign this, review it with counsel, et cetera, because that's a CYA email. if that answers the question.
It does. It does. Brenda, do you have any thoughts about this before we move on?
Yeah, I think these kinds of situations create, whole nother issue, and that is with regards to what if one of the parties doesn't comply with one part of it, of what you've agreed to, where's the meat? And so people can have any kind of side agreements they want, but if there's not a default clause or a method by which, if they don't do these things, what will happen, then you're looking at starting a litigation all over again. So I think it's important when you do write up agreements that you consider how complicated you want to make these agreements. And that's in general mediations, but with the Florida bar, we are typically looking at specifically fees and not all the other murky
We are. We threw this one in.
Yes.
Not only may Mary may not get a court order even adopting what their agreement is, but even if it is adopted, your point is that it may be difficult to enforce. But
Sure.
I think both parties would be aware of that, because that's the case no matter what they've got for an agreement in a matrimonial lawyer. For a matrimonial lawyer, there may be problems with enforcing it, but this is what they agreed to. This is what the court's ordered.
Right.
They're ordered to do it. Now, if they have to go back to court to enforce that order, that's another day. But as far
Okay,
as I
so-
Am Trying's concerned, I Am Trying's got his money now.
Okay, but ladies, we need to
Right.
move ahead because of time and because we've had a couple of questions about, wait a minute, aren't we getting rather far afield from the scope of what this mediation is about? This mediation is about a professional fee dispute. And when the parties start bringing up these kinds of complicated legal issues, sometimes the best answer is, even though there's a legal impossibility embedded in there, is like, look, we got to stay focused on the fee dispute. And if a side agreement is going to make it impossible to resolve that fee dispute, then we need to keep the parties on that. That is the scope of what we are there to do. Now, having said that, I am going to move us ahead to the next scenario so that we make sure that we get there. Brenda, this is yours.
So are we close to a settlement? But no. I Am Trying counters with a 15% reduction from the total bill, but not including the retainer. And he will refund to Mary all proceeds received that exceeds the amount, if any. However, he wants a full release from Mary of any potential claims arising from his representation of her in this case. In general, my experience is a full release signals the start of a new mediation. Full release encompasses a lot of issues that previously maybe weren't anticipated in the case when you began the mediation or the negotiating process. So a full release typically raises a lot of issues, especially for a pro se individual who is more than likely not familiar with all the implications or the knowledge to make an informed decision. And as I said previously, with the Florida bar, the cases are typically narrow and they only deal with monetary amounts. But when a full release request comes up, I think the mediator has to be mindful that they're not lured into providing some type of legal advice as to what the meaning of this full release means. What is the language? In my opinion, as soon as I read a full release and the pro se party's eyes glaze over, they begin to ask for explanations and what does that mean? That's a signal to me that perhaps the mediation needs to be terminated, or maybe that party needs to seek legal advice to answer those questions, because I can't. However, on the other side, I would say specifically to the attorney, we're here to discuss the finite dollar amount that you're seeking. And all these other issues can be addressed in another setting or some other fashion, but this program, it does not encompass all the different various nuances that would come up with a full release. So that's my position on that.
Yeah, I have to say, I agree with you, Brenda, that, when this comes up, and it comes up frequently, and, interestingly, it only seems to come up in the pro se context, right? Because if you have counsel on both sides, and that's why the last little teaser on here is then again, self-determination. If you have got counsel representing both sides and counsel is responsible for providing the legal advice to his or her client about what is going on in the scenario, it may be conceivable that the lawyers will work out something that not only takes care of the fee aspect of this, which you are mediating, but they'll also deal with the other aspects of it as well. That's when both sides are represented. But when one side is unrepresented, I think you really can get into very deep water really fast here. And you might find yourself providing legal advice that you know you're not supposed to provide, you never intended to provide, and frankly, you don't want to be providing, right? So that is the reason that we put this slide in here, because what I typically say to the parties in this situation is, listen, if you can only resolve, because the attorney is the one who's saying, come on, let me get a full release out of this if I have to pay money. My response is, if you can resolve the fee aspect of it, then whatever happens in any other claim that arises from this representation, you won't have to deal with the dollars and cents that will already be off the table. And sometimes that is a winning explanation. I am going to go ahead and move us forward because I know we still have some questions.
10 seconds on this one.
10 seconds, go ahead.
You don't necessarily have to call it an impasse if the attorney doesn't give in. You can abate it, let Mary get a chance to speak to an attorney, and then if she agrees with a release, then you still have a deal and you can conclude it. So it's just give her that chance, give her a week or two to speak to somebody about it.
And I think that is an excellent point. The last bit of this that we want to make sure, because we're coming past our 70-minute mark, but we are going to take some questions, and we're going to throw some questions at you all for those of you who choose to stay and continue with this process with us. We're at 70 minutes, as I said. We have up to 90. Let's assume that Mary agrees, and we have to, what do we do with that? Well, we've already mentioned that you need to tell Mary that she's got the right to consult with an attorney before she signs any agreement. But the second part of this that we want to point out is that you, as the mediator, do not necessarily have to write down the agreement. You must have the agreement memorialized appropriately, and that is what your ethical obligation is per MEAC. That is also what your obligation is under the Florida family law rules of procedure, so that you know where you stand with respect to that. Chanel, we are ready to throw some polls at these participants who have been sitting here listening patiently. One of the beauties of Zoom is that we get to see what you all think and how you review this. I'm going to read the question and I'm going to read the answers, and by then you all will have responded and we'll get to see what the results are. Mary's got a cousin. She's an attorney in Ohio. She wants to call her cousin to discuss the offer. The mediator says, don't call your cousin. That would violate confidentiality. Or the second answer, go ahead and call your cousin. I need to tell your cousin about the confidentiality rules. Or the third answer, which is, if you call your cousin, I'm going to have to terminate the mediation. We're going to give everybody an opportunity to kind of, that's not quite settled yet, but we're getting there. This is a large group. There's a lot of responses. And we're just, so we got almost everybody. No, we don't, because the server's got to collect all these responses.
They're still coming in rapidly.
That's
so
right.
Let's just wait just a couple
That's
more
right.
seconds and
We're going to give it a little more time. Okay. We're close. We're getting there.
I'm gonna go ahead. I'll end the poll, and here are the
Yeah.
results.
There are the results. Okay. So, yes, where the majority of our respondents are on answer B, which was the answer that was designed to be the best choice for this one. Again, going back to that idea of outsiders to the mediation process who are invited in by one or more of the participants, that you need to make sure that they are also informed of the confidentiality strictures that will apply to the mediation. Otherwise, you might find yourself in a place where, all kinds of people are involved in your mediation that you don't have any knowledge of and don't have an opportunity to speak to. But that is, did I have to, okay. All right, now. So that is poll question number 1. Chanel, I'm going to shut this down and let you go to poll question number 2.
Oh, I think you took it for me.
Did I take, no, I'm sorry, you go ahead.
Make sure that I can launch. I think you need to launch it.
Stop sharing.
Okay, all right, okay, so I'm gonna do this. Okay, I need to stop sharing. All right, clicking that. All right. Now, how do we do the next poll question?
There we go.
Perfect. All right. So, okay, we had a lot of discussion about the ex-spouse, Martin. So Martin joins the mediation and says he's going to do this. If Mary agrees to increase the time sharing, Mary asks the mediator to write up the agreement. And how would you handle this one? The answers are A. No, we're not going to do this. That'd be fraud, duress, or unconscionability. I have to terminate the mediation, so that's what I'm doing. B, there's self-determination. The parties, this is a sustainable deal for purposes of reaching an agreement and concluding the mediation. Or C, the mediator says, wait a minute, when I ran my conflicts check for this, when ACAP sent it to me, Martin was a named party or a participant. I had no idea he was going to be involved in this mediation, so I didn't check. But I've checked again now, and lo and behold, Martin came to my former partner several years ago to discuss a marital dissolution. I have to terminate the session because of a conflict of interest. You've got my deepest apologies for not being able to raise this issue in advance. So let's see what everybody thinks.
Got a tie going here.
Yes, this is a fast, Chanel, everybody who is answering can see the percentages flick around like us on the poll. Okay, I think this is fascinating.
Yes.
Okay, so we've got about 70% of the responses. We're just going to let it get a little higher. Okay, I think that's good. All right. So when we created these polls, I'm going to tell you that Linda told me that she thought I was chickening out on this poll. But the reason I put this poll question in here is because this is a real life scenario. All right. And I want to make sure that everybody is thinking about these real life scenarios. We believe the best answer to this question is C, right? You're involved in this mediation, a stranger to the mediation is invited in, and then all of a sudden, lo and behold, you have a conflict. As soon as you discover the conflict, you've got to make the conflict apparent to the parties and take action based on that, which means you have to terminate the mediation because of the conflict of interest. Linda says I chickened out because it doesn't really get into the issue of what do you do with the hard questions. But I think we had a lot of discussion about that back in our scenarios, and I don't think we need to go back and repeat all of that again. But the best answer for this one is C. And Chanel, I'm going to let you go ahead and launch 3, or do I have to hit? Okay, I don't have to do anything, right?
Let me see. Okay, I can launch that one.
Okay. Okay, this is more typical of what you might get in a mediation when you walk in to talk to an opposing party. I am trying says, hey, Mary is crazy. She agreed to pay my fee. I'm willing to reduce my fee if it gets me out of the process, but we're not getting anywhere. Call the impasse, mediator. And the mediator says, A, I can't call an impasse unless both sides agree. We can't make any further progress and that we should adjourn. Or B, you're right, Mr. Trine. I think you're going to prevail. I'll tell her we're at impasse. Or C, I'll put the parties back in a joint session, explain that you have requested an impasse, and give Mary a chance to respond to that. And this was way too easy a poll question because look where everybody is. We are coalescing around answer C. And you know.
And that
wonderful.
comment just brought it to the top.
No, I know, but it was like, all of a sudden it was like, woo, wait, all of a sudden it was right there. Everybody was right on C,
Well-
which we believe is the best answer as well. If you get a request for an impasse, you know, one party doesn't necessarily have the formal right to say, I want an impasse. They can say that. But what the mediator's obligation then is to, and this is the smart, practical answer too. When one side says, I want to impasse, and you bring that information into the other room, hey, they're packing up. They're going out the door. They're ready to go. This is where they are. They don't feel like we're making any progress. You will shake the tree loose sometimes. Sometimes the parties who are receiving that message will suddenly have a lot more information to convey and a bigger change in position, which is why it makes practical sense to carry that information into the other room before you say we're at impasse, and not just let one party say it's impasse, we're done, and we're out of here. So,
Christina,
do-
there's a question
yes.
about the last one, and if I may take a little liberty with this, it says if all the parties have the agreement, apparently about waiving the conflict of interest, do you still have to terminate the mediation?
Well, that's an interesting question, right? So if a mediator has an actual conflict of interest, you get into that very kind of tricky area of whether a waiver is enough. MEAC says that if there's an actual conflict of interest, a waiver by the parties is not sufficient to get you off the hook as the mediator. You need to walk away and have them go through a different process. That's why it's so problematic in mediation, right? Because if you were going to, you can cure the conflict under the Florida rules of professional responsibility by getting a waiver and knowing an informed waiver. You can't always do that in the mediation context. Sometimes you just have to move forward and say, nope, we're not going to be able to continue with me. We're going to have to mediate it in a different context, which is bad news for Chanel when that happens. All right, well, we are coming right up on 9:25. I'm sorry, on 11:25. And so I think, ladies, do you have any concluding remarks? Linda?
Not really.
Brenda?
I think
Not
we've
really.
covered it.
All right, as I said initially, don't forget to reach out to Susan Austin if you need a mediator or a certificate of completion for your CME file. And if anyone who is listening to this needs to get a copy of the slides, could I ask you to convey that information to Susan Austin also, and we'll make sure that it gets sent out.
And I do want to say thank you all for spending this time with us.
Yes, it has been, this has been a very interactive group, and it's been a lot of fun.
One more time, the CLE number and the CME course number are both the same, 7329. If you need a certificate, please email saustin@floridabar.org. Thank you all.
Thank you.
Thank you.
Thank you, panelists.